The process of characterization involves 3 steps: asking what the relevant head of power is, determining the character of the federal law, and then finding the sufficient connection between the head of power as interpreted and the federal law as characterized. We talked about the details of this process in the video that is appearing on your screen. But today we will look at how the approach to the first question has changed the answers the High Court gives to the following steps of the characterization process. That is, we will see how the High Court has progressively shifted from a substantive to a narrow characterization of federal laws. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about the substantive and narrow characterization of laws. In previous videos, we talked about the process of characterization, and we have also discussed some of the most significant cases decided by the High Court in terms of interpreting the heads of power in section 51 of the Constitution. Today, we will bring these 2 topics together. We will talk about the problem of characterization. I have mentioned this before, remember? Because if I follow, for example, a literal approach to interpreting the Constitution, and particularly, let's say, section 51 of the Australian Constitution, then it would be easier to find a connection between the broad interpretation of the head of power and the legislation as I interpreted it. Do you see that? If I interpret the head of powers broadly, it is easier to accommodate laws that will touch on those subject matters of the head of power. This is called the problem of characterization. It's about how to interpret the appropriate head of power, how to interpret the scope of the law, and how to connect the 2 in a way that is more accommodating or not. The High Court of Australia, in its earlier phases and composition, tended to interpret the heads of power very narrowly. This meant that the federal law had to be characterized more substantively to fit the heads of power. What do I mean by substantively? The justices would analyze the text, but also dig deep into the purposes, the operation, and the effects of the law. It was a holistic approach to the law. It considered not only the written provisions, but also the law's aims. And they would consider the implications of that law to the established constitutional principles. Yes, I'm referring here to principles like the reserved powers of the states and the implied intergovernmental immunities. So instead of looking at what the law does, the substantive characterization also considered what the law could not do, based on the fundamental principles of the Constitution. In adopting the substantive characterization, the justices were saying that the Constitution should be interpreted as a whole, taking into account its federal basic structure. This led to the federal laws being more easily found to be unconstitutional. Take the case of R and Barger from 1908. There, the High Court found that a law that literally dealt with taxation was outside the scope of section 51(2) because it, in substance, was used to impose excise duties to regulate the conditions of manufacture of agricultural implements. In the reasons of the majority in this case, Chief Justice Griffith and Justice Barton and O'Connor said, in interpreting the grant of power, it must be considered not only with reference to other separate and independent grants, but also with reference to the powers reserved to the states. And they continued, an inquiry into the purpose of an act is not an inquiry into the motives of the legislature, but into the substance of the legislation. And for the purpose of determining whether an attempted exercise of legislative power is warranted by the Constitution, regard must be had to the substance, to things, not to mere words. Justice Isaacs dissented in this case. He questioned the majority whether the substantive characterization of a law would bring about the genuine interpretation of its constitutionality. For him, the formal character of the law was more important than its effects or purposes. In fact, as you already know, in the engineer's case, Justice Isaacs managed to shift the direction of the High Court's interpretive approach. From then on, the High Court adopted a wider interpretation of the heads of power, giving the widest possible meaning to the constitutional provisions. This approach led to a more formal or narrow characterization of laws, which ultimately rendered the law to be more easily characterized as fitting the head of power and thus to be constitutional. The literal interpretation of a head of power is more accommodating of the constitutionality of federal laws. And when interpreted narrowly or formally, federal laws need not generally be assessed in their purposes. Whatever the text of the law says, if fitting with the broadly interpreted head of power, is proven to be constitutional. If a law is about taxation, then, as it was in our embargo, even if it has clear effects in regulation conditions of labor, it would still fall within the ample scope and meaning of taxation under section 51(2) of the Constitution. The engineer's case and the literal interpretation of the Constitution that followed it paved the way to an expensive approach to the characterization of Commonwealth laws. The main method of characterization that the High Court uses today, then, is a narrow characterization of federal laws. Now, there's one further point here that needs to be addressed, and that relates to the dual or multiple characterization of the law. You see, when adopting the substantive characterization, the High Court did not accept a law that could be interpreted to fall within the scope of more than one head of power. The substantive characterization aimed at identifying the one true nature and character of the law, so multiple characterization did not make sense. But the question then becomes, with the change from a substantive to a narrow characterization, did this approach to multiple characterization of federal laws also change? I will answer that and some other questions in my next video. Make sure you are subscribed to Aussie Law and that you hit the bell icon so you are notified every time that I upload a new video. Leave a like to this video before you go, and I'll see you again soon. Until then, ciao.